In this video, we're going to cover the laws and jurisdictions of computer forensics. So first of all, there's three primary areas that you're going to see computer forensics. First, in the military, second, in law enforcement, and third, in the private sector and academia. And each of these are going to follow a pre-described set of standards and guidelines. One of these standards looks at forensics investigation, which involves acquisition of devices, materials, etc. that we're going to perform forensics on, then the analysis that we're going to do. From our analysis, come up with an examination of what actually happened, and then write up a report for that. And we'll talk about these steps more in a subsequent video. Additionally, we need to look at the rules of evidence, and these are going to differ depending on whether this is criminal or civil. Under criminal, we have the Frye standard. With the Frye standard, evidence that is based on scientific technique is admissible only where the technique is generally accepted as reliable in the scientific community. And then we have the Free standard, which is the federal rules of evidence that codifies law for United States federal courts. Under civil, we have the Federal Rules of Civil Procedure, which examines the methods, procedures, and practices used in civil cases. We have the Sedona Principles, which are a set of 14 principles that were developed by members at the Sedona Conference that apply to the basic principles of discovery, etc. And the next guideline pertains to presentation. Under presentation, we're going to have several different people that could be involved in the presentation, such as an expert witness, which a person whose opinion by virtue of education, training, certification, skills, or experience is accepted by the judge as an expert. Or we could have a friend of court who is someone who is not a party to the case and is not solicited by either party, but assists the court in offering information that bears on the case. And we could have other technical experts involved as well. When you're looking at digital evidence, you need to consider criminal versus civil law. Criminal law looks at beyond a reasonable doubt, meaning that there is no evidence of the contrary, whereas civil law looks at the preponderance of the evidence. So basically, if 50% or more evidence sides with one case, we're going to typically side with that case. So do these apply to IT security? Yes. In criminal law, to prosecute attackers and avoid breaking the law. And then in civil law, yes, to avoid or minimize civil trials and judgments. As you consider law, you need to consider the various jurisdictions that reside within the United States. Jurisdictions are areas of responsibilities where the government can make and enforce laws. First, we need to consider the Supreme Court, which is the final arbiter of the U.S. federal law and reviews cases that involve conflicts between the appellate court precedents or important constitutional issues. After the Supreme Court, we have the Circuit Court, which includes 13 different circuits. They do not conduct trials, rather they review district court decisions. So the 13 courts are listed here. You can see 11 of them represented by this color-coded representation of the United States. The 12th is the DC Circuit, and the 13th is the Federal Circuit, which has nationwide jurisdiction. Then you have district courts, and there are 94 districts that make decisions in trials that are only binding to the litigants. For example, Texas has 4 districts, Oklahoma has 3 districts, and Nebraska has 1 district. Finally, we need to consider international law. So the differences are wide and rapidly changing across all the world. And knowing these laws is important to multinational firms because forensics laws could be very different across all these different countries. Additionally, domestic firms that don't have any operations outside of the US still need to be concerned because some of their suppliers and buyers or even attackers may be in other countries, and we need to be worried about them as well. So here are a couple federal cybercrime laws that are important to know. The United States Code, Title 18, Part 1, Section 1030 says that hacking and denial of service or malware attacks are against code, and you're liable to be prosecuted if you engage in any of these behaviors. Additionally, the United States Code, Title 18, Part 1, Section 2511 says that the interception of electronic messages en route or after the message is received and stored is also illegal. However, if a company owns the email account of their employees, any email communication that is done within their organizational email is subject to review by the company. Thanks for watching my video. Feel free to click the links here to watch the next video of the playlist, continue to the next playlist, or subscribe.